Dear students, let us continue the law class. In the last classes, we have already discussed the communication of proposal and acceptance. Today, let us examine whether a proposal or acceptance can be withdrawn or revoked. Revocation simply means withdraw or cancel or repeal. These are the meaning of revocation. So once you send a proposal, can you withdraw it? Or once you send an acceptance, can you withdraw the acceptance you have made? So this is what we are going to see in this chapter, revocation of proposal and acceptance. Section 5 of the Indian Contract Act contains the provisions regarding revocation of a proposal or revocation of acceptance. That section says a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. Repeat. Proposal may be revoked at any time. A time is fixed. And what is the time? Before the communication of its acceptance. See, once you send a proposal, the person to whom you have sent the proposal, he has to accept it. And the acceptance has to be communicated to you. Till the time it is communicated to you, you have the chance to revoke or withdraw your proposal. So that is why section 5 says a proposal may be revoked at any time before the communication of its acceptance. It means the acceptance of the proposal is complete as against the proposer, but not afterwards. The communication of its acceptance is complete as against the proposal. So we have already seen that communication of acceptance is complete as against the proposer when the letter of acceptance is put in a course of transmission to the offerer so as to be out of the power of the acceptor, and as against the acceptor when it comes to the knowledge of the proposer. So we have already discussed the time up to which, the time of communication of the proposal and acceptance. As against the proposer when it is complete. When can you say the communication of the proposal is complete as against the proposal? And similarly, when it is complete as against the acceptor, the acceptance. So, when the letter of acceptance is put in a course of transmission to the offerer, there is a condition to that. Once it is posted or put in a course of transmission, it should be out of his reach. He cannot take back it. If it is put in the post box, then he cannot take it back. Then, when the letter of acceptance is put in the post box, we can say communication of an acceptance is complete as against the proposer. If A is the proposer, the communication of acceptance is complete when the acceptor puts his letter of acceptance in the post box. And what about the acceptor? When the communication of acceptance is complete according to him, and as against the acceptor, the acceptance has to reach the proposer. It has come to his knowledge. So the communication of acceptance is complete as against the proposer when the letter of acceptance is put in the post box, and as against the acceptor when that letter reaches the proposer. That means once the acceptance of the offer has already come to the knowledge of the offerer, withdrawal or revocation of the offer is not possible. We have discussed the time limit up to which revocation can be made. Revocation of the proposal can be made. So the proposer has time up to the communication of the letter of acceptance. The acceptor has put it in a course of transmission or put in the post box up to that time. After that time, proposal cannot be revoked because the proposal is accepted as far as the acceptor is concerned. He cannot take it back. He cannot revoke it. That is the revocation of proposal. For example, if A proposes by letters and by post to sell his house to B, A sent a letter to B proposing to sell his house to B, and B sends his acceptance also by post. Once B's acceptance, he has put it in the post box, then it cannot be revoked. We have already seen that A may revoke his proposal at any time before at the moment when B posts his acceptance to A. When the acceptor, here A, has accepted and it is communicated through a letter, and that letter when he has put in a course of transmission, that's put in the post box, up to that time the proposer has time to withdraw his proposal, and afterwards he cannot do that. Suppose A is not revoking or withdrawing his proposal. B has accepted it. B sent his acceptance by post. Now the question is whether B can revoke his acceptance. As far as A is concerned, once B has posted his letter of acceptance, the communication of the acceptance is complete, and then B cannot withdraw his acceptance. The proposal, A may revoke his proposal. B's acceptance, when he posts it, up to that time, proposal can be withdrawn. But his acceptance can be withdrawn at any time before or at the moment when the letter communicating the acceptance reaches the proposer A. Suppose B has sent his acceptance by post. Can B withdraw or revoke his acceptance? The answer is yes, but there is a time limit. What is the time limit? Before his acceptance reaches the proposer, up to that time, he can withdraw his acceptance. That is why we say we may revoke his acceptance at any time, before or at the moment when the letter communicating the acceptance reaches the proposer A, but not afterwards. That is because communication of acceptance is complete two ways, as against the acceptor and as against the proposer. As against the acceptor, it is complete when he put his letter of acceptance in a course of transmission. As against the proposer, it is complete when it reaches him, when it comes to his knowledge. Let us take another example. X proposes by a letter to sell his house to Y at a certain price. Before the proposal reaches the other party, the prospective acceptor, X send a telegram to Y withdrawing his proposal. The proposal has not reached the acceptor, but it is out of the power of the proposer. He has already sent it by post. Here, the revocation of the proposal is complete as against A. Revocation is possible because the proposal has not reached the other party. He can revoke. When the revocation can be complete as far as the acceptor is concerned, because it is revocation of acceptance. When the acceptor send a telegram, when that telegram is dispatched so that it is out of his power, before receiving the proposal, by Y, here X send a proposal to Y through a letter. The letter has not reached Y. Before it reaches Y, X changes his mind and decides not to sell his property. So immediately he sent a telegram to Y. So the proposal is revoked by a telegram. Now, when this revocation is complete, that is the question before us. As far as the prospective acceptor as well as the proposer, in both ways, when it is complete, the revocation is complete. As far as the proposer is concerned, revocation is complete when the telegram is dispatched. And because the proposal has not reached the other party. So before that, he can withdraw his proposal. So he send a telegram, and once the telegram is dispatched, the communication of the revocation is complete as far as X is concerned. Then what about the position of Y? As far as Y is concerned, the revocation of the proposal is complete when Y receives the telegram. The telegram sent by X, when it is received by Y, then communication of the revocation is complete against Y and not before that. That is revocation of the proposal by X sent to Y. X sent a proposal, thereafter he sent a telegram to Y. Before the proposal is received by Y, X sent the telegram withdrawing the proposal. Therefore, the revocation of the proposal is complete as far as X is concerned when he dispatches the telegram. But that revocation is complete as against Y only when he receives that telegram. That is as far as X is concerned. Suppose X sent the proposal, it is not revoked. Y accepted it and he sent his acceptance by a letter. Now the question is whether Y can revoke his acceptance, and if so, when? What is the time limit? Then suppose first he sent the acceptance by post. Before that letter of acceptance reaches X, suppose Y revokes acceptance by a telegram. In that case, that revocation is complete against Y when the telegram is dispatched, and it is complete against X when the telegram reaches or comes to the knowledge of X. So we have to distinguish the difference between the two. In both the cases, as far as communication of revocation is complete, we have to look it from the point of view of the proposer and from the point of view of the acceptor. Once a proposal is sent by letter, whether the proposer can withdraw it, revoke it, and if so, when, up to what time. If he is revoking his proposal by a telegram, when the telegram is dispatched, communication of revocation is complete as far as X is concerned. But it is as regards X is concerned only. But as far as Y is concerned, when he receives the telegram only, the communication of the telegram or the communication of the revocation is complete. When the proposer dispatches his revocation, as it is put in a course of transmission so as to be out of his power, communication of the revocation is complete as far as the proposer is concerned. But it will be complete as against the acceptor when it comes to his knowledge only, when the telegram is received by him. That is the proposal. Then if it is not revoked by X, proposal is not revoked, Y received it and is accepting it, and his acceptance is sent by post. After sending the acceptance, Y feels that it has to be withdrawn or revoked. So how can he do that? It has to be revoked before his acceptance reaches the proposer. his revocation of acceptance, if it is sent by a telegram, it is complete as against Y. Y is the acceptor when the telegram is dispatched. It is complete against the proposer X when the telegram comes to his knowledge or received by him. So, therefore, both the proposal as well as the acceptance can be revoked by the proposer as well as the acceptor, subject to the time limit prescribed in section 5. Now, the next question is how an offer can be revoked, or the methods of revocation of an offer. It is contained in section. They say it can be withdrawn by a notice of revocation by the offerer. Offerer can send a notice informing that the offer I have already sent to you is hereby withdrawn. That is by a notice. The time limit we have already discussed. Before that time limit, he has to send this notice. That is one method. The second method, in the proposal, a time limit is prescribed for its acceptance. If up to that time that proposal is not accepted, the proposal automatically lapses. So, by lapse of time prescribed for acceptance, it stands revoked, automatically revoked. Suppose no time is prescribed in the proposal, then by the lapse of a reasonable time without communicating acceptance. Acceptance is not sent by the acceptor within prescribed time or within a reasonable time. So, by the lapse of such time, it stands lapsed. The third condition is that by failure to fulfill condition prescribed or accept, the proposal may contain certain conditions for acceptance. There, simply acceptance of the proposal will not do. The condition prescribed has to be performed by the acceptor. If there is a failure on the part of the acceptor to fulfill such a condition prescribed also, the offer stands revoked. Let us take an example. A proposes to sell his house to B for 50 lakhs, provided that B agrees to lease his land to A. So, selling of A's house to B at a certain price is subject to the condition that B should agree to lease his land to A. So, a condition is prescribed. If B agrees to this condition and accordingly communicate his acceptance to A, then it is okay. Communication of acceptance is complete. But if B refuses to lease his land to A, then the offer automatically stands revoked. Why? Because the proposer has prescribed a condition, the acceptor has failed to accept this condition. And without accepting this condition, acceptance of the proposal cannot be complete. He is not prepared to accept that condition. He is not prepared to lease his land to A. He is prepared to accept the proposal, but he is not agreeable to lease out his land to A. If that is the case, the proposal sent by A stands automatically revoked. Now another condition is that by death or insanity of the proposer, if that comes to the knowledge of the acceptor before acceptance. For example, A sent a proposal to B. Before B accepts that proposal, B dies or he became insane. Before the proposal is accepted, the proposer dies or becomes insane, then also the proposal stands automatically revoked. Another method is by a counter offer. Let us take the above example. A proposed to sell his house to B for 50 lakhs. If B agrees to lease out his land to A. Now B send a counter offer to A stating that I am prepared to buy your house for 40 lakhs and lease out my land. So there have been changes in the proposal. That is, a counter offer has been sent by B to A. So it is not acceptance. Now only if A accepts this counter offer, then only we can say it is acceptance. By sending a counter offer, the original offer stands revoked. Now suppose non-acceptance of the offer according to the prescribed mode or usual mode. If the offer is not accepted in the prescribed mode by the proposer. The proposer has prescribed a mode of acceptance, but the acceptor has not accepted is according to the prescribed mode or usual mode. It is, as we have already stated, it is also condition. Then it stands automatically revoked. Then by subsequent illegality, an offer has been sent by one party to the other party to do or not to do something. After sending that proposal, but before accepting it, whatever is to be performed or not to be performed as per the proposal has become illegal as per the government order. That is what is called a subsequent illegality. That at the time when the proposal was sent, whatever he has proposed to be done by the acceptor was legal. But before its acceptance, government has declared such act as illegal. So we can say it is subsequent illegality. By that subsequent illegality, the proposal becomes automatically revoked. Thus, we can see that a proposal or acceptance may be withdrawn or revoked as per the rules laid down in sections 5 and 6 of the Indian Contract Act. So, what is the result of revocation? When there is a valid revocation of either the acceptance or either the offer or the acceptance, then no contract is made. No rights or duties are created as per that proposal or acceptance. When it is validly revoked by either of the party, either the proposal or the acceptance. Now let us see some of the case laws on this point. In JK Enterprises vs. State of Madhya Pradesh, the petitioner sent a tender for purchase of 10 leaves tendu leaves, Tendu, tendu leaves. The petitioner sent a tender for purchase of tendu leaves. A date is given. It was sent on 11th January 93. January 93, 11th January 93, the proposal was sent. The tender was sent on 11th January 93. See, actually, tenders are offers for offer. Inviting offers, we can say invitation to offer. Once the one party has advertised a tender, on the basis of that, another party has sent a tender. Here it is for the purchase of tendu leaves. It was sent on 11th January 93. But the respondent, the other party, sent his acceptance by registered post only on 12th February 93, after 1 month. But that acceptance did not reach the petitioner. Proposal sent, the other party accepted it, and the acceptance was communicated by a registered post after 1 month. But even that letter of acceptance did not reach the petitioner. Then, by a fax message sent on 3/3/93, March 3rd, 93, the petitioner had withdrawn or revoked his offer. So we have to understand that the proposal was sent on 11th January. It was sent by registered post on February 2nd, but that letter has not reached the petitioner proposer. Therefore, the petitioner withdrawn or revoked his proposal by a fax message on 3rd March 93. There was a dispute between the two parties. The person who has accepted it wanted to perform the contract. When it reached the court held that a valid contract is already come into existence on 12th February 93, the date on which the letter of acceptance was posted by the acceptor. A valid contract is already come into existence on 12th. So you have to understand that the proposal for purchase of tendu leaves was sent on 11th January 93. The other party has accepted it, and the acceptance was communicated by a registered post on 12th February 93, and the proposal was withdrawn on 3rd March 93. When there was a dispute between the two parties, the court has held that the letter of acceptance did not reach the petitioner, number one, and the petitioner had withdrawn his offer on that basis. But when the letter of acceptance was posted by the acceptor, communication of acceptance is complete as far as the proposer is concerned. Therefore, a valid contract is already come into existence on 12th February 93, and for there could be no revocation of the offer by the fax message. The reason is that a proposal may be revoked at any time before communication of its acceptance is complete as against the proposer, but not afterwards. Here, the communication of the acceptance is complete as against the proposer when the letter of acceptance is put in a course of transmission on 12th February 93 to the offerer, so as to be out of the power of the acceptor. Therefore, after that date, അതായത് after 12th February 93, the proposer cannot revoke his proposal. That is JK Enterprises versus State of Madhya Pradesh. In the case of revocation of proposal by post, we have already seen that proposal may be sent by post, acceptance may be sent by post, revocation may also be by post. If the revocation is by post, revocation of the proposal is by post, no revocation is possible after the communication is of its acceptance. No revocation is possible after the communication of the acceptance. If the proposal is already accepted and the communication of the acceptance is complete as far as the acceptor is concerned, thereafter no revocation is possible. Suppose in response to my offer sent by post to you, you post the letter of acceptance to me. As soon as you have posted the letter of acceptance, the contract is complete against me and I become bound thereby. Thereafter, my power to revoke the offer comes to an end. So, the point to be borne in mind is that after the communication of the acceptance is complete, no revocation is possible. A proposal is revoked by lapse of time prescribed or within a reasonable time. We have already seen that. On that point, there is a case in Ramsgate Victoria Hotel versus Monday Floor. The defendant M made an offer to purchase shares in the company in June. The defendant made an offer to purchase shares in the company in June. The company has offered for public subscription certain shares. He has made an application M. The offer was accepted by the company, but the shares were allotted in November only. Application was sent in June. The offer was accepted by the company and shares were allotted only in November. The applicant has made his application in June. The company has allotted shares only in November. There is so much time in between. The court held that the offer has lapsed as the same has not been accepted within a reasonable time. So, you can accept within the prescribed time or within a reasonable time. In another case, an offerer who has mentioned that his offer is open until a particular time. Offerer says that his offer is open until a particular time. He is not debarred from revoking the offer earlier than that time, if he so likes. For example, A has made an offer to sell his property to B for a certain price, stating that the offer is open till 12th June. The offer is open till 12th June. Until the offer is accepted by the other party, no contract is made. The offer is open until a particular date. Up to that, any person can accept it. But before 12th June, he sold the property to another person, say on 11th. B has accepted the offer on 12th and sued for specific performance. He accepted the offer on 12th. Before that, he sold the property. He wanted the property, so I accept your offer. B's acceptance of the offer on 12th is of no use, as the offer has already been revoked on the sale on 11th. It is already sold, so thereby the proposal stands revoked. As regards terms and conditions printed over leaf, say there may be certain terms and conditions printed on tickets, receipts, etc. There should be reasonable notice of the contractual terms. The customer should have notice of the terms. For example, obtaining a signature of the customer on the ticket, mentioning on the face of the ticket, as for condition C over leaf, etc. In other words, the condition should be brought to the knowledge of the customers. In Prakash Road Lines Limited versus HMT Bearing, it was held that the carrier is bound to deliver the goods consigned at the appointed destination. Merely printing on the back of the receipt that the goods are transferred at the owner's risk will not absolve the transporter from his duty. See, if certain conditions are printed over leaf, then you should, on the face of the ticket or receipt, you should say for condition C over leaf. So that means the customer's notice is invited. Without doing that, you cannot say that the customers are informed about the conditions. That is not possible. That is why the court held that in this particular case, the goods consigned at the appointed destination, the party should deliver the goods consigned. In another case, Parker South Eastern Railway Company, the plaintiff deposited a bag in the cloakroom of the railway company. In the railway stations, you will see we can deposit our bag or luggages for safe custody in a particular room. It is called a cloakroom. And you will get a receipt. Here also a receipt is given. On the face of the receipt, it was stated C back. It was stated C back to C over leaf. And on the over leaf, conditions were printed. And one condition was that the liability of the company for any package is limited to 10 pounds. English case, it was 10 pounds. The plaintiff lost a bag costing 24 pounds. It is said the company had made reasonably sufficient efforts to draw the attention of the customers and it was binding. Here, the customer will get only 10 pounds because the company has given in the notice that the maximum liability they will take up is only 10 pounds and customer's notice was drawn on the basis of the information given on the face of the receipt. Similarly, in Government of Rajasthan versus PV Seshayar, the question for consideration before the Andhra Pradesh High Court was as to whether a purchaser of a lottery ticket was bound by the terms and conditions printed in small print overleaf the ticket. In the case, the plaintiff purchased a Rajasthan government state lottery for ₹1. During that period, the cost of a ticket was ₹1 or 2 like that. And the ticket was lost through pickpocket. The first prize was 2,50,000. Even though ticket was lost, he claimed the first prize. It was proved that plaintiff had purchased the ticket and nobody else had claimed the prize. The defendant insisted on production of the original ticket. The court held that plaintiff was not bound by the terms printed on the reverse of the ticket in small prints, and he could claim the price even without production of the original ticket. In another case, Richardson, Spencer and Company versus Roundtree, plaintiff was a passenger in the defendant's ship. The ticket contained a condition limiting the company's liability to $100 for any injury to the passenger or loss of luggage. The ticket was given folded up. Moreover, some of the conditions on the ticket got obstructed by a stamp put over it. Plaintiff sustained injuries during the voyage and claimed more amount, but the company wanted to limit its liability to $100 on the basis of the condition printed on the ticket. The dispute was taken to the court, and the court held that reasonably sufficient notice of terms had not been given to the plaintiff, and therefore the plaintiff is entitled to recover the compensation for the whole loss. If the acceptor fails to fulfill the condition precedent to the acceptance, offer stands revoked. Acceptor fails to fulfill, we have already seen that if certain conditions are prescribed, the acceptor has to fulfill those conditions. If those conditions are not fulfilled, then it stands revoked. In state of Madhya Pradesh versus Govardhan Das, tender for sale of certain goods were invited subject to the condition that 25% amount was to be paid when the tender was accepted. Here A's tender was the highest and it was accepted. But A failed to fulfill the condition by paying 25% of the amount. When the dispute reached the court held that no contract had arisen merely because A's tender was accepted, as the condition precedent was not accepted, and therefore the offer stands revoked. So, in all these cases, what we have seen is that if conditions are prescribed, the acceptor has to follow that condition. If failure to follow those conditions will result in automatic revocation of the proposal. Okay, so we have been discussing about revocation of proposal and acceptance, and now we have to continue the class with another chapter, that is consideration. It is a very important chapter, consideration, and we will discuss it in the next class. Okay, thank you.